What's going on, YouTube? All right, I'm still under the weather, but I'm still about to put in that work and share this information. So please do, if you like and appreciate the information and the time I dedicate to giving the information, I would appreciate the love and support by liking the video, commenting on the video, subscribing, and definitely pressing that the alert. So every time I upload a video, you'll get notified. Click that bell for the notification on YouTube, and also click the link below inside the description to join the Hellraiser Legacy, to be a part of our private underground network. For all the information and resources that I go over is all available inside the network. Any and everything that I share on YouTube is we have a complete arsenal and body of work and bodies of work inside the network. So make sure y'all check it out. Alright, so this video is entitled How UCC Applies Inside of Court. The administrative courts are administering the international bankruptcy, and therefore they operate in the international admiralty, maritime, commercial jurisdiction, the law of the sea, and they are bound by the UCC. The UCC is a colorable version of admiralty. Colorable admiralty jurisdiction is also known as statutory jurisdiction, color of law. In order for the UCC to be implemented, there has to be a provision requiring it to be in harmony with the common law. The requirement may be found at UCC section 1-103, which, when invoked, along with UCC section 1-207, which is also known as UCC 1-308, which is also the new version of section 1-207, which is the universal reservation of rights. It represents a powerful method of protecting your natural rights from encroachment by the government. The recourse appears in the Uniform Commercial Code at 1-103.6, which says the code is complementary to common law, which remains in force. For those people that keep saying that the UCC is not enforceable, or the UCC is not used anymore and all the other stuff, except we're displaced by the code. Okay, the code is complementary to the common law, which remains in force, except when displaced by the code. A statute should be constructed in harmony with the common law, unless there is a clear legislative intent to abrogate the common law. UCC 1-103.6. This is the strategy we use in court. The code recognizes the common law. If it did not recognize the common law, the government would have had to admit to the corporate state that it is bankrupt, and it is completely owned by its creditors, which is me and you. But it is not expedient to admit this. So the code was written so as not to abolish the common law entirely. Therefore, if you have made a sufficient, timely, and explicit reservation of your rights at 1-207, which is also 1-308, you may then insist that the statutes be constructed in harmony with the common law. Example: if the charge is a traffic ticket, you demand that the court produce the injured person who has filed a verified complaint. If there's no injured party, there's no crime. I'm sorry. If there's no injured party, there is no crime, so you can't be penalized or charged for a crime or or a citation or citational lawsuit. That's exactly what citations are and tickets are. They are city-made lawsuits, city-made civil lawsuits. For example, you were charged with failure to buckle up your seatbelt. You may ask the court who who was injured as a result of your failure to buckle up. However, if the judge won't listen to you and just moves ahead with the case, then you will want to read to him the last sentence of UCC 103.6, which states the code cannot be read to preclude a common law section. Tell the judge, Your Honor, or My Honor. Be careful with the wordplay in court. I will use My Honor. Tell the judge, My Honor, I can sue you under the common law for violating my rights under the Uniform Commercial Code. I have a remedy under the UCC to preserve my rights under the common law. I have exercised the remedy, and now you must construe this statute in harmony with the common law. To be in harmony with the common law, you must come forth with the damaged party. If there's no damaged party, there is no case. If the judge insists on proceeding with the case, just act confused and ask this question. Let me see if I understand, Your Honor, or My Honor. Has this court made a legal determination that sections 1-207 and 1-308 and 1-103 of the Uniform Commercial Code, which is the system of law you are operating under, are not valid law before this court? Now the judge is in a jam, because when you speak, when you speak, and when you're able to speak in court, and you utilize that time to speak the right thing and the right verbiage, now your words become part of the record, because that little person that's sitting next to the judge, she's recording and documenting everything. So now that's on the record. Remember, anything you say can and will be used against you, or in this case, what you say can be used with you and against the court of law to defend you. How can a court throw out one part of the code and uphold the other? Next question. If he answers yes, then you say, I put this court on notice that I am appealing your legal determination. Of course, the higher court will uphold the code on appeal. The judge knows this. So once again, you have them boxed in the corner. The quick four sentence method. This method, according to multiple sources, was used by a woman in Los Angeles at an initial appearance in an administrative court, no jury, no injured party, to close the books on the charge. When you close the case, they leave you alone. The first sentence expressly declines consent, which prevents the presumption of consent. The second sentence declines the offer of the contract. An administrative court is a dispute resolution service by contract. The third sentence declines to become surety via the official legal person, aka legal person named debtor in the debt money system, which is your corporate entity. The fourth demands a bond against harm. Court officials hold insurance bonds which can be called upon to indemnify anybody that may be damaged, which will be you in this case. So first, I do not consent to these proceedings. Second, your offer is not accepted. Third, I do not consent to being surety for this case and these proceedings. Fourth, I demand the bond be immediately brought forward so I can see who will indemnify me if I am damaged. At this point, the judge reportedly dismissed the case and told her to leave the court. Someone observing this method repeated it and was also released. After the second case, the judge told everyone to go home and closed the court for the day, leaving the court. Now that's funny. They say, fuck this shit, we gotta wrap this shit up. Because everybody finna start doing this shit now. If the court officials expect someone to use this method, they will typically reschedule the case to the end of the day so that the others will not see this. Of course, judges do not want this method known, and the bar attorneys will not and cannot do this for you. Understand that. So when we hiring these lawyers and stuff like that, and so-called public defenders to defend us on our behalf, they can't even use these methods and remedies that are available for us and for the people to really and surely secure our best interests. So we have to play our own personal roles and our own personal private attorneys for ourselves. We have to educate ourselves on the laws that governs us, but also protects us inside of these courts, especially. If you enter into this court or into the court intending to do this, you must do it yourself as soon as possible. Do not let them distract and dissuade you, because if you agree to engage in any issue they attempt to raise, you are consenting to their jurisdiction. Just showing up in court, you taking a big risk, because once you enter into that courtroom and you go in between those pearly gates with those flags in front of that judge, you have now entered inside onto the ship, and now you're inside their jurisdiction. It don't matter who you are or what you claiming. So now you have to sit there and defend it with every word that come out your mouth. If with the wrong word, the wrong answer will contract you with the courts. Which is why I personally recommend avoiding court at all costs, if possible. That's why we do. If we get hit or addressed with a bullshit case or citation or ticket, whatever the case is, where we have to appear in court, and they give us those 30 days or so to appear in court. As soon as we get that notice, we need to be acting. We need to be sending in our reservations of rights or giving notice and acknowledgement of our reservations of rights to the clerk of the court. And if we do appear in court, we're issuing a special notice of special appearance, so they know before we come where we stand, where we legally stand, and everything is already on the record before we board the ship. We have to prepare ourselves and arm ourselves and defend ourselves before we enter onto the ship. Now, if you don't, your fate is held at the mercy of the courts, which is a situation nobody wants to be in. Avoid court at all costs. Do the paperwork. Send in your affidavits of truth. Send in your reservations of rights. Put those things on the record. Address these things to the courts, the clerk, and the judge. Do not add anything. Say only the 4 sentences. If necessary, repeat, 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 repeat. Memorize all 4 sentences or keep a copy. All right, man. That's it, man. So that was right on 15 minutes. Trying to keep shit kind of short and sweet. Uh, Definitely, like I say, sign up and join Hellraiser Legacy by clicking the link below. Uh, where we have access, you'll have access to all the affidavits and stuff like that to deal with all different variations of issues and stuff like that. So peace out. I'm about to go ahead and lay it down. I'll let y'all later.